So probate sucks, and you've heard that 1,000 times, and you're finally ready to do something about it. In fact, you're going to do your own estate plan. Yay! Congratulations, except for the whole part where you said you're going to do your own estate plan. In today's episode, we are going to talk all about DIY estate planning. And maybe at the end of it, you'll decide, yes, I've got it. I am absolutely confident now and can handle my own estate planning. Or you'll think, oh, maybe I should go and talk to somebody. Either way, the decision is yours. I'm only here to help you make a more educated decision. Welcome to Gavels Down, Voices Up, where we flip the script on conventional legal discussions. I'm Rachel King, here to guide you through the murky waters of family law, estate conflicts, inheritance disputes, all of the dramas. We're not just talking about law, we're talking about how it affects your life, your rights, your future, and your money. From the courtroom to your living room, we bring you insights that matter. Dive into each episode ready to challenge, learn, and grow. Ready to change the dialogue? Let's begin. Gavels down, voices up. So doing your own estate plan, we've all heard of the legal Zooms and the form fillers and all of the things. I bet if you did a Google search on doing your own estate plan, you've probably got more than one page of Google that is going to have some kind of directory or self-help service to do it. And it can be really tempting because maybe you called your local attorney and they're quoting you thousands of dollars, but these online services are promoting hundreds of dollars for what seems to be the exact same paperwork. And it probably is very similar paperwork. I mean, an estate plan is made up of a will, a trust, a power of attorney, advanced healthcare directive, and maybe some others sprinkled in. But typically, that is what it is. So, yes, money matters, and I'm all about saving money just like you are. But let's take a break. Let's take a breather and let's think it through. Why? Because I am a California certified specialist in probate and I only do probate litigation. That is the only area of law I do. If you want your estate plan drafted, go find a certified specialist that does estate drafting. If everybody is getting along, that is fantastic. Find an attorney that likes that. If everybody's in conflict, you're coming knocking at my door. And why does all of this matter? Because some of the most contested, most expensive cases that I've handled are the result of people doing their own estate plan. So while it can seem really great while you're alive to save a few bucks or maybe even a few thousand, and again, thousands of dollars can be the difference, it really sucks when you saved $1,000 today, but everybody's spending hundreds of thousands of dollars fighting after you die. Unless you think that is what you want, the gift that you want to keep on giving to your family, in which case success. But most people that are doing an estate plan don't want that. So if you do your estate plan successfully, that is fantastic. And if you can save a couple of bucks along the way, high five, I am all about it. But if it goes wrong, it can cost exponentially more money on the other side. So when you are doing an estate plan, you can draft them yourself. You can very likely hire some kind of document prep service or a paralegal to draft your documents. And of course, you can hire an attorney. Maybe I'm biased because I'm an attorney. I don't even think maybe, I certainly am. An attorney can give you legal advice about your situation, can tell you how to fill out those forms, what the documents need to say, so that what you want actually happens. And legal advice is unique to attorneys. So if you are doing your own estate plan at the very, very basic level, you're not getting legal advice. You're hoping, fingers crossed, that what you want actually happens and that what you think your document says, it actually does. I had a client who did an estate plan, created a power of attorney. It was durable, so it was going to go all the way through incapacity. And she thought, yeah, this is going to allow my husband, they'd been married for, 50 some odd years, to take care of all of our assets and to be able to live peaceably and take care of her for the rest of her life. Well, she didn't develop dementia, but she did end up in a pretty significant car accident that left her permanently unable to make decisions, I guess is the best way. She couldn't move. She couldn't communicate. It was unclear whether she could process what was going on. She was older when this happened, I think 68 years old. So husband comes and says, well, I've got this power of attorney. I can do it all. And for many, many years, that's exactly right. Husband had no problems, partly because they were married, partly because they were on a lot of their joint bank accounts and assets together. But there came a situation where husband needed to make a pretty significant decision regarding the real estate, their primary residence. It needed a reverse mortgage, and it needed a reverse mortgage because they had to retrofit the house in order to make it more accessible, not only for her, but also for him. And even though this power of attorney had been used forever, for lots of years, as soon as it went in front of that loan officer or the powers that be that do reverse mortgages, they put a screeching halt on it and said, absolutely not. We don't like this power of attorney. So he came to me and said, oh my gosh, what do I do? No matter what I tried, no matter how many people I talked to, this particular institution said, we're just not accepting it. Now, we can't get wife to sign a new one, right? So what do? We had to go into probate court, get a conservatorship, spend thousands of dollars trying to do this just so he could do what he thought he already had. Who knows if whether he talked to an attorney, he would have been able to get a power of attorney that would let him do all of these things prior to his wife becoming incapacitated. Maybe they could have done. But one thing that we do know for sure is that they didn't do that. They did the documents themselves. And had they talked to an attorney, it's very likely that the documents would have been completed a little bit different, and husband would have not had to go through the conservatorship process. I say all this to say I'm fairly certain it could have all been avoided, but there's no guarantees, and you never know what would have happened if you did things another way. So for this, we're going to say it couldn't have hurt, and it might have saved a lot of money. Let's take a quick break. If you're navigating the twists and turns of divorce, you might be wondering, getting divorced, now what? That's actually the title of my upcoming book, designed to guide you through the challenging and emotional process of divorce. It's packed with real-life stories, expert tips, and motivational insights to empower you every step of the way. While it's not available just yet, you can join the waitlist to make sure you don't miss out. Head over to rachelkingattorney.com to sign up to be the first to get a copy and enter to win a free signed copy as soon as it releases. Arm yourself with the knowledge to move forward confidently through this challenging time. Now let's get back to the show. Have you ever tried to do your own estate plan? I have. Well, I mean, I'm an attorney, so of course I do my own estate plan, but I mean using one of those online softwares. You go through and it's a lot of checking the boxes. If you don't know what they're saying, if you don't understand the exact question or what the box checking implementation actually is going to do, or you don't like your options, but you're like, I have to choose one, but I really want this other thing to happen, you're not getting a custom document. And so what you want to have happen doesn't necessarily mean it's going to happen. The biggest risk with doing your own estate plan is that because you don't understand the laws behind it, maybe you don't understand how the documents work and what is going to be their legal effect, it can be really hard to create them yourself. That's why we have attorneys. So maybe you can do it, but that's something to really think about. I would say the takeaway from that specific risk is how complex is your family? Do you want a whole bunch of control, or are you willing to just say, hey, I'm only doing this to stay out of California probate court. My spouse gets to inherit everything after my spouse dies. I don't really care if they give away everything to their new significant other, but ultimately maybe if they want, it goes to our kids. Why do I say that's fairly simple? Because that's like what the law does, right? So if you're looking at your estate plan and you're really trying to do something that mimics what the probate court would do or the probate laws would do, then maybe you can fill out your own estate plan because it's simple. I would caveat to say you don't actually know if what you want done is going to be the same as the probate code unless you talk to an attorney, but I digress. So you've created the documents, you're going to do them, and you're pretty confident that they say what you want them to say and that they're going to do what you want them to do. That's fantastic. If not, then we'll find out later down the road and your family will be hiring me. But nonetheless, for this, we'll assume that you filled them out and now you have to execute them. Another big issue is execution. I can't tell you how many wills come into my office with people saying, well, I have a will right here. And I look at it and I say, it's just not like legally created, right? You didn't follow, or the person that drafted it didn't follow the legal requirements of the state of California. I had a family come in and say, but we recorded the entire thing. We have it on videotape. We have grandpa saying exactly what he wants and why, and so it should be a will. Except that in California, video wills aren't valid. Yeah, they can be added on to show the intention, potentially the capacity and all of that to support or back up a written will, but standalone, they're not valid. So making sure that the documents that you've drafted on your own not only are correct, but that they're handled and executed the right way. Do they need to be witnessed? Do they need to be notarized? Who can witness? Can my daughter witness my will even though she's going to inherit? Can my attorney daughter witness my will even though she's going to inherit? Can my daughter write my will? Can I docu-sign my will? All of these things are really significant. And chances are you haven't got the nuanced explanations under some kind of document prep service. Maybe, maybe not. I had once where the power of attorney acknowledgement, the notary acknowledgement, was on the last page. There was no other documents and there was date differences. So maybe this power of attorney was valid and that the notary had made just a clerical mistake, but we couldn't find the notary. The notary hadn't turned in their book to the state of California. And all we're looking at is a power of attorney that has dates and some really weird oddities when it came to this notary. Court ultimately said, nope, not validly executed. So execution, just as important as filling out the documents. And it can really be a challenge, again, that's not noticed until you actually need to use the documents. So if this isn't enough at this point to at least talk to a professional to find out if you are in a position to do them yourself or if it makes more sense to go with an attorney, think this. Statistics, and we all know that not all statistics are right, but statistically, DIY estate planning documents are 50% more likely to end up failing, being in prolonged court proceedings, and costing exponentially more than if they had been done while you were alive with an attorney handled correctly. And if you use an attorney, you might have another person that can testify in court if necessary that says, yes, I talked to this person. This is really what they wanted. Family disputes about what the documents say, whether they were valid and what the intention. Again, another reason for very, very high conflict and expensive litigation after somebody dies, or maybe even while they're alive. Think about a dementia case where mom has dementia, lacks capacity, thought she put an estate plan together all on her own, but didn't. And now we have the kids all fighting about where mom should live. Should she be at home? Should she be in memory care? Does she want life-saving measures? Does she not want life-saving measures? What is it going to look like? Should we sell? Should we not? Should we continue to support youngest brother who's been kind of on mom's wing since he was birthed? All of these are decisions that many times can cause conflict while you're still alive among your children. Again, not trying to fearmonger here, really trying to provide you with some scenarios that are very, very common so that you can look at your own situation and decide, is it complex? Would it be beneficial for me to talk to an attorney? And as a couple of my clients have said over the years, no, I don't want to spend money on you. That is going to be their problem after I die. I don't care and I don't want to spend a penny on it while I'm alive. That's totally fair too. At least you're making the decision and you know why you're making it. Maybe at that point, scribble a note to your kids or your family that says, I was going to do it, but I decided not to, so that they're not all thinking, oh my gosh, why didn't she do it while she was alive? Of course, I'm a probate litigator, so I've got all of the stories gone wrong. Stories that go right, they don't walk through my door. However, people's failure to do it the right way is what gives me job security. I am very confident that even if you choose to do it the right way, there's going to be plenty of people that don't, and I will continue to have work and continue to have a job. So don't be them. I'll still be able to feed my family. You should go out and do it the right way so that you can avoid having your family have to hire an attorney because, man, attorneys are expensive. If nothing else, protect your legacy, protect your wishes, make sure that what you want to happen actually does happen by creating documents that are going to do just that. Talking to an attorney, it doesn't hurt. You can still choose move forward or not move forward. You can still decide to do your own documents. But before you rush out there and start creating your own will, take a second and maybe talk to an attorney. Have you tried to draft your own estate planning? How much did it cost? Was it easy? Was it confusing? Do you wish you'd done it differently? I would love to hear all of the stories about you and your self-drafting estate plan situation. Or maybe you know somebody who did. That wraps up another episode of Gavels Down, Voices Up. If you found value in our discussion today, please subscribe, leave a review, and share with someone who needs these insights. Your engagement helps us grow and impact more lives. I'm Rachel King, thanking you for listening and reminding you to speak up because every voice deserves to be heard.